This is a brand new document. Please download it. Open a Kami tab. Drag and drop. Okay, you should be opening it for the first time, so you should not be seeing that option to select. Okay, and here are your notes that you will fill in. And there is no Pear Deck or anything like that, so I just need to drop the notes over here.
Will Smith.
That is indeed Will Smith.
Yo.
All right, so refresher on the structure of our courts. Remember, we've got two systems, the state system of courts and the federal system of courts. And if you're wondering, isn't there a third, those of you who have ever gotten a traffic ticket or anything like that and went to a municipal court, yes, but that is subsumed under the state court system. In addition to two systems, we have two different types of courts. There's the trial court, where things start, and then there is the appellate court for appeals from trial courts, issues that can only be resolved by higher courts. Okay. And then two types of laws. Civil, which involves just who was wrong and who was right. It can involve paying damages, ceasing some harmful behavior. And then there is criminal, which is not really about you harming someone else. It is about violating the laws. Remember, if Sky kills Caitlin, the court case is going to be the state of Missouri versus Sky, not Sky versus the family of dead Caitlin. Right? It's just not how it works. Right? It's not that we don't care about Caitlin, but let's face it, what really happened here was Sky broke the law. Right? And that's what the state is concerned about. Right? Okay. Now, the job of the trial courts. Remember, they handle criminal cases, but they also handle civil cases. Right? Often judges specialize. For example, and we'll refer back to good old Judge Judy a lot, Judge Judy just handles civil cases. Right? Because those are the ones most easily dealt with in TV. Right? I don't think we want like a serial killer to be decided guilty or innocent by Judge Judy in 30 minutes minus commercial breaks. That seems like a bad way for justice to get done. And trial courts are the ones where evidence is examined. Now you're going to think, that just don't they all do that? No, not really. So the trial court is the one that is primarily there to decide, in the first case, right or wrong, guilt or innocence. And they reach verdicts called decisions, or decisions called verdicts is how I should say that, right? Guilt or innocence, right or wrong, liable or not. These verdicts take different forms. If we're talking about a criminal case, a person is either convicted or acquitted. Now, again, you'll often hear that just as guilty, not guilty. Same thing. In a civil trial, it's just which side is correct. And again, correct can mean different things. Right? Does Trevor owe Allison money? Right? Does Tommy need to turn down the music so that Claire can sleep next door? Right? All of those kinds of things. Right? Is Bridget, as the baroness of a multi-billion-dollar pharmaceutical company, going to have to cough up some money over the opioid epidemic? No, Bridget, you're not going to have to. Okay. Just declare bankruptcy. No, that won't always get you out of it. All right, but again, correct can mean lots of different things in a civil trial. Criminal trials are much more simple in terms of what a conviction or acquittal means. Oh, what are we doing there? Google Slides. All right. Now, the different players that are involved in the trial court. Okay, the initiating actor. In a civil case, it's the plaintiff. Nobody's a defendant until there's a plaintiff. Right? Bridget and Bridget's other cronies cranking out those opioids, killing people and making billions of dollars. They weren't defendants until somebody started suing them. In a criminal case, it's the prosecutor. And in both cases, the person accused is a defendant. Sometimes you will see in a civil case, and I guess even in a criminal case, somebody referred to as the respondent. That's pretty uncommon. And as far as what you are all likely to encounter as citizens out there reading newspapers or watching something on TV or YouTube, you'll just hear them referred to as defendants, right? Only those of you that would become a lawyer would hear other terms used. Anybody want to become a lawyer in this class? Some of you will get used to that. All right. Awesome. Okay. And the judge is there to manage the process. With one exception here, in the case of what's called a bench trial, the judge is the one who actually makes that verdict, not a jury. And in a criminal case, the defendant decides whether it will be a bench trial or not. You have the right to a jury trial. I would guess that until recently, I would not have been able to expect that my students had heard of a bench trial, but that talk about those has actually crept into the news in some of these cases of police killings, where police have now recently been charged. Because typically what police do in those cases is they choose a bench trial out of fear that they will not be able to find an objective jury and will get better treatment from a judge. But most of the time, if there's a verdict, it is decided by a jury. While you guys are finishing that up, for my students who want to be lawyers, be careful what type of law you choose to do. The days of just being able to go to law school and pop out guaranteed a fat salary, salary might not be the right word because a lot of you would have worked for billable hours. That's kind of changed, like LegalZoom, cheap lawyers who work in India and understand English common law system and speak English have knocked out a lot of that lower level work that lawyers used to be able to make a lot of money on. So you kind of have to be careful and make sure that you pick the right area of law and then don't spend too much money going to law school. We will later research lawyers and you'll see you do not have to go to a top flight law school in order to have success. So be careful. I have a friend who, some of it's his own fault, he was really good at singing and got himself a couple of master's degrees in music and only later in life went to school to be a lawyer. It was tough when he got out. And it wasn't because he was old and there was some discrimination against old lawyers. No, it's just hard to get a job as a lawyer. Okay, or can be. Now I've scared you all and ruined your dreams. It's okay. He's doing fine now. He works for he's like a public defender for appeals cases in the state level, and he's really good at it. And he looks like a perfect lawyer. He's like a really tall, thin, handsome guy. It's like my wife made the mistake of saying he's tall, dark, and handsome, what every girl wants. It's like, what are you saying here? I am none of those things. All right. Okay, moving on. Well, I say that. Funny, very funny Google Slides. Really, you're going to make me run through it again? Okay. All right, moving on. Now I want you all to just bask in the glow of Ben Matlock there for a second with his fantastic suits. And it was the same suit every time. All right. Have you guys had enough Ben Matlock? That's right, Aiden. You can never have too much Ben Matlock. All right, well done. Right. Okay. There are different trial systems to learn about. I already told you that the judge mostly manages the system, but that's only true in this system, which is okay because it's the one that most of you are likely to deal with if you ever deal with a trial system at all. It is, in true American fashion, a competitive system. It's called adversarial for a reason. It is very much the prosecution or plaintiff versus the defendant. The goal of the competition is to persuade. And it can be a nasty battle to persuade. And the target of your persuasion is either a jury or a judge. And as it typically goes in the American adversarial system, the side with the best argument wins. Now, how you get to the best argument has lots of different things. And again, the American court system can be pretty nasty. We'll talk more about that when we kind of compare the two systems. The other system is the inquisitorial system. Now, this is associated more clearly with Europe, particularly continental Europe. The British system, aside from the kind of seemingly bizarre continued tradition of wearing wigs in court, is like ours. I mean, other than that, it's an adversarial type system, but continental Europe is different. In this system, the judge is leading the show. And I don't mean in the same sense that I said judges manage the trials here. In this case, in this system, the judge is doing a lot of the important work. The judge will call and question the witnesses. The judge will be responsible for collecting the evidence. I don't mean that the judge is going to go out like a detective and gather it, but the judge is going to look at the evidence that's been assembled for and against the defendant. They're going to decide what's important, and they're going to present that in court. Okay. In our system, who does that work? It's not the jury. Who calls and questions the witnesses? Prosecutor, defendant, the lawyers, right? Not the judge. I mean, the judge can say whether some evidence is allowed or not allowed, that kind of thing. But the lawyers are responsible for collecting and presenting the evidence. And one of the other things that's important there is when you're talking about lawyers doing it, one of the things, and we'll talk some more about this later, is if Claire is the prosecutor and Sanaya is the defense attorney, Sanaya has the right to something called discovery, and that is Claire has to share evidence with Sanaya's side. Right? You can't just sit on some evidence that would be really good for Sanaya's side just because you don't want her to have it because you want to win. So there's a mechanism for getting all of that stuff out. In an inquisitorial system, and I don't want to make it sound corrupt, there can be corrupt judges, but there's nothing inherently corrupt about the system. But if a judge decides some evidence isn't important, it just might not come out. And the reason I go into kind of belabored the point with this is that this is not a system where the judge is supposed to be an impartial actor. The judge has a very specific mandate. The judge's job is to find the truth. Was everybody finished with that slide? Okay. That's all right, Dakota. I can put it back up there. I mean, it would have been better if it had been the Ben Matlock slide, so we could have kept looking at Ben Matlock, but Monty Python's okay too. All right. Now, in terms of comparing the two, one of the questions to consider is which one of these systems is better. As with so many things, it depends on what you want, but let's look at some of the criticisms. The adversarial system gets kind of called out for being just about winning. I mean, I would not want to be called as a witness in court. I mean, that's just like a good way to have your character, your credibility smeared by the other side. People trying all kinds of stuff to dig up dirt on you. It's a mean and nasty system because what matters is just winning. Right? And what critics would say is that the casualty of this is not just the victims who are the witnesses and other people involved who might get dragged through the mud, but that it's not about finding the truth. Right? It's about spinning the best story, but not necessarily about getting at the truth. I mean, think about O.J. Simpson's trials, right, that always come up, and for whatever reason, I'm only now starting to get a couple of students per class that have not heard about the O.J. Simpson trials. So in the criminal case, he is found not guilty. He's acquitted. In the civil case, the wrongful death case, about the same exact murders, he is found responsible for their deaths. Right? Now, he can't be both. Right? He can't be, well, this guy's like, oh my gosh. Well, I mean, he can be both. Like, the world did not break when that happened. It kept on turning just like it had been. But right, he can't logically be both. He can't be innocent of a crime and responsible for the deaths. Right? And a lot of people were unhappy with the verdict in the O.J. Simpson trial because they thought that he paid for high-dollar lawyers. They'd been able to really basically just outgun the prosecution and get him acquitted. I don't know that that's actually the case. And I used to work with an African-American man who grew up in St. Louis, and he's like, yeah, the reaction to the verdict there was very different than what you experienced here. And I have no doubt that that's the case. Okay. Inquisitorial systems aren't without their criticisms as well. The big one here, especially looking at it from an American perspective, is that judges are way too powerful. And again, that's just our perspective. That doesn't mean they actually have too much power. And in this case, we also put the truth above the rights of individuals. Now, what's more important? Let's see. Tommy, what's more important, truth or rights? Probably the truth. Tommy, I'm just going to make a phone call real quick. I almost forgot. You're going to be charged with a crime. Now, what's more important, truth or rights? Definitely not the truth, right? I mean, that's it. That's a totally rational response. And Tommy, I picked on you because I would have been very shocked if you had said otherwise. Right? Everybody cares about the truth until they're the one that's been accused of a crime. And then at that point, right, people are very concerned with their rights. Okay. And that's totally understandable. And the U.S. system is very much rights-centric. The presumption of innocence until you're proven guilty. Whereas an inquisitorial system, it kind of flips this. In some, I will generalize by saying it almost assumes that the accused person is guilty, or if it's a civil case, that they've done something wrong. But there are some systems where actually the burden of proof is not on the prosecution, it's on you as the defendant to prove that you are innocent or not responsible, not liable in a civil case. And so just understand that those are two kind of very different sets of criticisms. Now, in talking about the courts, still most things do not actually end up in a courtroom. Right? And especially not in a courtroom where defendant and prosecution and representation and judges, everybody is present. Most of this stuff gets settled out of court, right, in what's called the pretrial process. Now, pretrial process resolutions are just they're negotiated settlements. If it's a civil case, we call it an out-of-court settlement. And the estimates I found here, it's a pretty wide range as to what proportion of cases in civil court are settled, or in civil cases are settled out of court. Somewhere between 2/3 to 9 out of 10 are settled without going to court. And the example I want to use here, just so that you understand, things that get settled aren't necessarily settled because they're not important. One, I think it still stands as the biggest case. I don't even think the opioids will come close. So you can breathe a little easier there, Bridget, partly because I'm going to guess is just an opioid barren. Your respiration is not suppressed by lots of opiates coursing through your veins. But for now, I think the Tobacco Master Settlement of 1998 is the biggest. It was an out-of-court settlement between several states and some of the biggest players in the tobacco industry, and it was, as you can see there, a $206 billion settlement. That's huge. One of those lawyers that was involved instantly became incredibly wealthy. And also, the states are just now running out of that money. I mean, it was huge. In criminal cases, we don't call it an out-of-court settlement. We call it a plea bargain. Bargain might not be the word you would think about it if you're the accused. All right. But here, right, you might think that plea bargains would be, or any kind of out-of-court settlement would be less common in a criminal case because, I mean, let's face it, if Caleb gets sued for something in a civil court and he loses, Caleb might have to pay money, but he's not going to go to prison. In a criminal case, of course, you could go to jail or prison. And yet, in this case, we see that at least 9 out of every 10 is settled at the plea bargain stage. And really, I've only included that number just because it seems that some people are still sticking to it. The higher end is much more likely to be the better number at this point in time. All right. Now, as far as the pretrial process, we're going to come back to look at plea bargaining and some of the controversy around that issue, but for now, we'll just kind of keep chugging away through the process. In a criminal case, if you want a jury trial, you are guaranteed a jury trial. Doesn't matter if we're talking about state or federal level, level of court. And you are guaranteed that by the Sixth Amendment. It's that positive right that guarantees you a speedy public trial with a jury and political representation if you can't afford it. In a federal civil case, at least, this only applies to federal civil cases, but the Seventh Amendment guarantees you a jury trial unless you signed it away with an arbitration clause in a contract. And then the amendment really can't help you. Now, that said, a lot of states also offer jury trials for civil cases. Right? Missouri is one of those. And again, if you don't want a jury, and there are some cases where you might not, you can, if you're a criminal defendant, request a bench trial. If it's a civil case, plaintiff or defendant could request a bench trial. Depending on the jurisdiction, You might have different arrangements for how they have to agree on what kind of trial to have. But again, in a criminal case, the defendant is always the one who can choose whether it's going to be a bench or a jury trial. It's not something the prosecution can determine. Does everybody have all of that?